pronounced my name. She got it correct. Apparently a big debate about that. The debate I had with the NAT board was how much time I was going to give this talk. There's a much longer version of this presentation on my website that I give yearly to Lawline as a CLE provider. So when I was talking to them, they first had to get it down to 20 minutes. I said, I can't do that. So they emailed me back the next day. It's like, okay, fine, we can give you 10 minutes. I don't understand. I gave a 2-hour presentation. Now you want it in 10 minutes. So they emailed me back again and said, okay, fine, 15 minutes. I said, okay, 20, 10, 15, 45 minutes, I can do that. So that's what we're going to do here. I have a 45-minute presentation where I'm not going to crack any patent attorney jokes just because I don't know any. If anyone knows any patent attorney jokes, feel free to shout them out. Otherwise, let's keep questions sort of limited because I don't have too much time. Is that a patent attorney joke? No? Okay. I thought every time I give a talk, I'm hoping for one. But okay, anyway. First, in responding to an office action, basically, now everything that David just taught you, if you didn't get it right, too bad, it's too late. Once it's set, you can't add any new matter. You can sort of finagle things. You try and do that in Europe, Germany especially. If you don't have the exact wording in, you're done. You have to take the exact wording from the summary or from somewhere where it's more important to have in the summary in Europe. But in any case, you now work with what you got. And on top of that, you need to remember what you did 2, 3, or sometimes 5 years ago. And you look back at your writing from 3 years ago where you were, and you have to figure out what did I mean and how do I clean this up. It's more fun when you're cleaning up someone else's language, there's someone else to blame. But then on the flip side, I'm going to go through an example, first of a crazy office action. So this was a claim in an application. Let's see if I figure out the laser pointer. Laser pointer. The device of claim 1, wherein, whatever, you don't need the details, the device is coupled to a neutral wire. So simple electrical claim, we couple something to a wire. The office action says C heart 5B. So presumably he means figure 5B. You have to figure that out sometimes, but there's no further explanation. So I looked at heart figure 5B, and this is what I saw. Real office action. I'm giving you a real-world example of what you see at the patent office sometimes. Now, examination sometimes is better than this. Let's say it's usually better than this. But I get more laughs on this, neutral wire. Can anyone find the neutral wire? Just to read this in case you can't see it. This is amplitude on the y-axis. This is time on the x-axis. Where is the neutral wire? Couldn't tell you. Anyway, so in the telephone interview, examiner has to get his SPI, which is patent attorney lingo, patent office lingo for supervising primary examiner on the phone, which is good because then there's someone else you can discuss. The problem is when the examiner who does this is the supervisor, and then you have bigger problems. That happens too. And anyway, he refuses to discuss this claim, discussing the dependent claim, discussing around the issue, and it was worse than this. Every single rejection. Claim 1, it was rejected due to figure 5B. Claim 2, 5C. Claim 3, 5E, and so forth. It went sequentially. No relation whatsoever. After 20 minutes, the examiner says, we don't have enough time. What do you want me to do? I'm given 6, 7, 8 hours maybe to go back and forth and examine this application and try and figure out what this talks about. And meanwhile, you're dealing with somebody who probably could be making 3 to 5 times more if he could get a job in the private sector, or if you're a law firm or engineer or whatever it is. Many of these guys are coming from outside of the country. Now it's less so. More so you get people who are native English speakers, but you have to deal with this, and you have to deal with it. These are people working for the government that are given a certain amount of time, and depending on the politics going on in the patent office, they're given less or more time or whatever it is. They may be very good at what they do, they may not be. It's all over the place, and it depends on art unit as well. We'll get into that. There's certain art units, just you hit certain art units, expect to appeal, plan to appeal. In certain art units, they're not allowing a thing through. Do a lot of software and business method patents. It's just brutal right now. If anyone can tell me a way to draft this is a serious question. If anyone knows after the Alice case the proper way to draft a claim for a pure software application, please tell me because I'm stuck right now. It used to be the law changed every 10 years and every 5 years and every 3 years, sort of State Street and Bank Street, 3 years, 2 years, the singularity is near. It's like to the point where It changes faster than, for those of you who have read, I forgot who, Kurzweil's books. He says technology is increasing so fast that eventually things that we create with machines will catch up to the mind, will augment our mind, and it will just increase at an infinite pace because it gets there. That's how I feel with business method patents. Singularity in terms of claim language is near. It's just every 6 months now the language changes. So you need to look at your application from 5 years ago, deal with these rejections, and figure out what to do with it. So what you do is the first thing that you see is something like this. And what I'm going to try and do for you is I've broken this down into a step-by-step method. And basically, when you get an office action, you're going to get pages and pages of telling you what's going on there. Pages of rejections. It could be 20, 30 pages. It could say 6 references. And the problem is you see this whole big thing before you, and you need to figure out what to do with it. So, and it's just overwhelming to see this whole thing. So my method that I'm going to go through, I call it the LOTA, or LOTA if you want to pronounce it, method. It's going to go through 4 steps. It's just basically a 4-step iterative method that you're going to repeat over and over until you get the big picture. It's basically taking away that emotional thing, and we're going to go through step by step each line of the claim and so forth until you digest it, and then you put it back together, and you're going to see the whole picture again. So first, look at this. So this, mail date, first thing you're going to want to do, you're going to want to docket your dates. Case file, and so forth, examiner. And this is the first sheet that you're going to see. This sheet sometimes is helpful, sometimes not. Sometimes it has correct information. Sometimes it doesn't. So here, claims 1 through 20 are pending. 1 through 10, 15 through 20 are withdrawn from consideration. 11 through 14 are rejected. Everything else is examiner restricted. I happen to get them all back together in rejoinder for a fun talk on restriction requirements, where they say it's multiple inventions because you describe 2 sometimes just slight variations, or the method and device. They'll split it into 2 applications, so it's less work. You file individual and so forth. That's in my full talk. I'm not going to go into that today. But in any case, first thing you do is docket the deadlines. Most important thing is do not miss a deadline. I'm not an expert on malpractice. Thankfully, I haven't had to deal with that. But what I've heard is a huge malpractice issue for attorneys is not necessarily doing a bad job, it's missing a deadline. You miss a deadline, it goes abandoned. Usually you can fix anything at the patent office. There's one thing that's required to fix anything. Just yell it out. What do you do to fix a problem at the patent office? Pay a fee, money. That's usually a problem. If you miss a 6-month deadline, you pay more fees. You revive the application. After 2 years, you can revive. So that was all the way back to my patent bar course. I remember the instructor there was saying, if you weren't sure what the question was on the patent bar exam, you can narrow it down, choose one of the answers and pay a fee. So what I do is I use a system called DocketTrack. Use a free plug for DocketTrack. I love it because they just started a patent system. Bruce Young is going to talk about docketing systems more tomorrow, I believe. But what they will do is they will actually, you set it up to copy not only you, but you copy the DocketTrack system on the USPTO electronic dockets, and they will send them an email, and in the morning when I come into my office, and when I see 52 emails from foreign clients, among them are one from DocketTrack that says, we'll put in the date of the rejection, list of references, and it will docket the date. So like I got an office action May 8, 2014, it'll automatically docket in 3-month and 6-month date in my docketing system and sends me reminders. This isn't responding to an office per se, but this is really important to docket these dates and make sure to hit it up by the deadline. So 3 months is a regular deadline. I send my invoices with an electronic system, automatically sends the client my reminder at 30 days, your invoice is overdue. This is more about practice. I don't do work without, it depends on the client. Most of my clients, I don't do work without getting paid. I send them the bill, they pay it, then I do the work. Don't have to spend your time billing because I want to spend my time responding to office actions. And then 3 months is a regular deadline. At 5 months, if you still haven't heard from them and they're not telling you, you really start bugging them, make phone calls, docket all that stuff that you've called them and so forth. Then after that, one of the first things I do, this is new for this presentation, is there's a patent attorney out in California who may be here for all I know. He runs a website called examinerwatchdog.com. This website is great because you know what you're up against. It will tell you, if you look up you look up your examiner, this is Benjamin Leno, good guy. I say that because he let him a patent go through some bias. is the one that I'm going to talk about today. It's like a 64% allowance rate. And it'll tell you how many abandoned, how many appeals. You get a sense of it. And you can also look up by art unit. So for example, Yandeta Reda, this is all public data. I don't know if she's here attending the conference. If she is, I'll be gone tomorrow. So Yandeta Reda at art unit 3622, she has a 2% allowance rate. If you hit up that examiner, insert your expletive. 3 out of 150 published cases allowed, and they're probably due to appeals anyway. So you set up your claims to appeal. Save yourself the trouble of spending too much time. You know, one response, wait for the final rejection, make sure your claims are perfect, no 112 issues, stuff like that, because you're probably going to have to appeal. Now, on the other hand, I'm not going to read this out loud, but that's the examiner's name in art unit 2835. I got to include humor in this somewhere. You know, patent stuff isn't necessarily the, you know, whatever. But art unit 2835, he has a 92.3% allowance rate, 671 out of 746. Most of the art unit is like this. You can search by art unit, you can get a feel for that art unit. You get into 3622, they're all 0 to 10%. I mean, there's guys, I've heard stories, I think Diane, once wrote this on the NAP practice group, that you saw an examiner that on his door had a 0% allowance rate and was proud of it. I think that was you, I don't know if it was you or somebody wrote that on there. So, you know what you're up against, you can strategize along that way. You may prefer not to look and just deal with it first. I'm too curious, I look. But, and then before we get started, make sure the reference is valid, check the earliest filing dates. It used to be when you could swear behind a reference, you cared more because oftentimes rejections were 102E, which was less than a year ago with a published patent application, and you might actually have an earlier filing date, or you swear behind. Won't go into that too much because you really can't swear behind on anything you're filing today, and I assume most people who are here are for today filed applications. Since the law changed, we're now a first-to-file system. Review the examiner's search history. This is something no one ever taught me, but I just sort of figured out that if you look at after the office action, you can see how much they searched. You can see what classes and subclasses they searched. They give a restriction, and they say restricted to class 705, and they search 379 anyway, and your other one was in 379, and say, hey, your restriction made no sense. I've never gotten anywhere with that argument, but you can't tell an examiner the restriction requirement made no sense. It doesn't work. No. Anyway, and you'll see, you get a sense of where did they search, how much searching do they do, how close are these references, you know, did they understand what they were looking at? For example, David gave the example of fingerprint, or the fingerprint, help me out here, fingerprint something versus the other. Image is fingerprint or fingerprint image are totally two different things. You get a sense of where they searched and how much. And the reality is most first office actions are poor, because they don't take the time to read it. Oftentimes they read the claims. Oftentimes they don't understand it. Whatever it is. Or they're just plain old saving it for the second office action when they cite the better rejection. Because many times people don't respond to first office action, so you know, whatever happens, happens. And the examiners are not typically, unless they're new, like within their first year, typically no one is giving them oversight on the first office action. They get oversight when they allow a case, and now someone else looks at it, now they can get into trouble. So first office action is like 90% rejection. The first patent attorney that I got trained from, he told me, if you draft a claim and it's allowed at the first office action, your claim was terrible. You should have drafted broader. You could have gotten more. If you get more, you get the rejection. So, and then you have to argue it. So sometimes I explain it to clients like this. It's like you have health insurance, it's kind of like that. You put the claim through the first time, it's rejected, you now have to go call, wait on hold, and fight for it until you get the claim through. The wording fits exactly. Okay. So they've gotten a little better. I've noticed healthcare has gotten a little better since Obamacare came in, and now they're like, no, we have to try and do a little better before the government completely takes over our job. But I'm near Washington, so I won't speak too much about that. So, okay, check for 101, 102. So these are the different types of rejections. So just get a sense of what's going on. A 101 rejection, as David said, you didn't see them very often a couple of years ago. Now, anytime you're in business method software area, you see them whether it's deserved or not. 102 is it's new, is it cited in one rejection. 103 is obvious over a combination of references. 112, structural type rejections. You didn't use a semicolon, you said A instead of said, or whatever. So when you see the first office action, you can either send it to the client without comment or you can review it first. In general, I like to give my clients some information. I tell them, you know, here's a few sentences, here's what's going on in the office action in plain English. If it's 10 pages of 112 rejections, which I'll admit, I feel like Alcoholics Anonymous meeting, but I'll admit I've gotten plenty of 112 rejections, which is you didn't draft the claims properly, or the examiner, sometimes the examiner doesn't understand it. I don't care, whatever, that could be cleaned up, usually. This is really bad. Enablement, that's a pretty bigger problem. But you can clean it up. I'll say, skip to page 8. Page 8, here's a substantive thing. They cited Goldstein in view of Huang, and they combined them and said that it discloses your invention, or whatever it is. So most clients will want to see some clients, some information, some direction, but it also depends on the technology. I have a client who is apparently, she's a professor at a university in New Jersey, and she's a foremost expert in boronizing titanium in the world. I have a third patent about to issue for her for, well, a third file, second issue, for boronizing titanium. I don't get it so much, to be honest. But, so I show her this, these are the references, and I say, you tell me what that says. Is that boronizing titanium? I mean, or, you know, I'm giving a facetious example, it's more specific than that. But I send the client the art, and remember, the goal is to respond in the best manner to get the broadest claims allowed. So whatever tools work for you in order to get the broadest claims allowed, that's what you do. Whether it's seek help from other attorneys, and that practice list is great. The email list is great. People answer your questions and so forth. I'm a frequent commenter on there. Sometimes I use it to rant when I'm too upset with something examiners are doing. You just ignore those emails and skip to the substantive ones. That's totally fine. I won't know who's really reading, who's responding, you know, who's just lurking anyway. But anyway, the goal in mind is to get the broadest claims available. So if it means consulting with your client, great. A good number of my clients haven't a clue about this stuff. They have a broad general idea, and I'm writing the technology. I am, you know, inventing the in-depth versions of it and putting all the computer processors and network nodes and so forth. So, you know, and they don't care, they don't want to look at it, just get me a patent. You know, they're running their business. Patent is a side thing, whatever. You know, they want patents, and you just get it for them. All right, so now I'm going to step into the actual rejections. So the goal is we're going to do this in management pieces. First thing I recommend is a don't. Don't read the examiner's argument first. Who cares what the examiner says? They're going to confuse you. Unless you know yourself, I can quote you various self-help books, Shakespeare, or whatever it is. You need to know yourself before you know other people. You need to understand yourself in your own arguments. And on top of that, you're not going to remember what you wrote or what it's about. And sometimes a simple case you will, but if it's a complex case, you really need to understand it. So first thing is refresh your memory. Review your patent application and your claims. And then after you understand it, I mean, I actually go through an exercise, and especially have my associates go through an exercise where I tell them, first thing you do is you write first paragraph, what is your application? And give me a citation. This will eventually be used in the office action, so it's not just an empty exercise. Give me a paragraph on what your application is about. Don't just take the abstract, that's cheating. You can take a sentence from the abstract, a sentence here, cite it. Everything is citations. Everything cite paragraph numbers because the examiner can actually look. And I'll show examples of this later on in the presentation. And after that, do the prior art, give me a paragraph on each of the pieces of prior art. I haven't touched the examiner's argument, I don't want to know what they are, usually. If it's really stupid, it's really simple, you might not want to do this, but this is in a substantive case. Again, use whatever method works for you, but I'm giving you a method of breaking this down very systematic. And if you have a paragraph of the prior art with citations, every sentence have a citation. It discloses a light bulb changer, which first step is it grabs the light bulb and unscrews it, and then it brings it in an arm, puts in the other one. Each sentence, paragraph 72, paragraph 75, and so forth. And now that they've written this paragraph, now we're going to use this later to describe what our invention is, and we haven't muddied the water, and what the prior art cites, and we haven't muddied the water with the examiner's arguments. So we basically say, my invention discloses features A and B. This prior art reference discloses B and C. This one discloses B and D. None of them disclose A and C together. And I basically, that's the substance of the response. And this should take about an hour to do. New associates, it takes about 8 to 20 hours to do. And then they get down to 10, and then they get down to 5, and then they leave. Anyway, so here's an example. A spherical ball with internal transponder freely movable about interior space. Wait, did I skip that? I'm sorry, I hit the thing. So, with a transponder freely movable about an interior space with a transponder pulls to gravitational bottom. So this is paragraph 39. So this is an example of the points that I put in the paragraph on one of my applications. So the reason I'm using this one is it's going to be visual, as you will soon see. There it is. There is this transponder. This is basically an RFID transmitter in a bingo ball. He is doing RFID bingo. That's all this patent is. So the whole idea, it's actually a pretty cool idea. I mean, it's simple enough, and it's patented if anyone wants to license it. Is the basic idea is when you're playing the bingo game and you have the bingo balls, that you can, you have the balls come out, it automatically reads the balls as they come out and puts them on the screen, and you can have it called B52. Here, I'll point for the game. You can have it called B52, and it will actually tell you what's going on. So that's what it is, and it's a resin ball with this thing in the middle. So what he's got is freely movable in the interior space. And side note, just interesting fact, is at least in the state of New Jersey where I live, bingo is ridiculously regulated, and he almost decided not to go through with this because the balls have to be equally weighted. So a thing inside moving around, we had to make sure we could make the transponder circular and equally weighted so you wouldn't have a problem with the regulations for bingo. No idea how regulated bingo games are. Anyway, prevents the ball from getting lost by rolling away as the transponder is constantly working against the centrifugal motion of the ball. So this was stuff that I put in the application when I drafted it, is how am I going to sell this to the patent office? And I disagree with David here for a second. I love background in the invention. The reason I like it is because it gives you a chance to sell your invention to the patent office. It gives you a few paragraphs to tell you what is the prior art, what is the problem. But you don't want to give it away. You don't want to lead too obviously to what you're getting into. But you might talk about in general the problems. But there is the caveat, which David would argue the other point is, don't bother because you're risking hurting yourself. So the way to get around that is put that in detailed description. You talk about now the problem is transponder is constantly working against the centrifugal motion of the ball, meaning it won't let the ball roll away because you have this other ball inside rolling away. So I ended up, you don't know when you're drafting the claim, I didn't know that was going to be useful. You put the kitchen sink in the patent application, you draft everything as broadly as possible. You don't know how you're going to amend what prior art is going to be cited. However good your prior art search is, there's a reference that you get a Japanese examiner that gets a reference from Japan you never would have found, which has happened to me. And then it's like, what am I going to do with that? Then you got to start reworking the whole thing, and you got to find what's in your application. If it wasn't in your application, you're done. So that's important to keep everything as much as possible in the application. So further, as recited in paragraph 39, this is important implications for efficient reading of data on the transponder, as the reader is placed immediately below or next to a known position of the transponder and the ball's resting position. In other words, your ball is rolling. This is actually the prior art one, but the transponder would fall to the bottom, and your reader is right below as the